Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the Benami transactions. The law on the Benami transactions was made very clear by the Union of India case, in which the Supreme Court held that the transactions which have been entered before the 2016 Act will not be covered by the Prohibition of Benami Property Transaction Act 1988 as amended by 2016. This was a big relief to the assessee. But the Income Tax Department filed a review application of this judgment in the Honorable Supreme Court. After filing the review petition, the department became very active in filing the appeals against the order passed by the tribunals in the high courts, and the plea of the department was that because the review petition has been filed, so the appeals of the revenue should be allowed. What approach should be taken in these type of matters has been decided by the Honorable Madras High Court in the case of Deputy Commissioner of Income Tax, Benami Prohibition and others versus Anjani Constructions Pvt Limited. And this case is reported in 478 ITR at page number 670, and the date of the judgment is 23rd February 2024. With this background, that where the Supreme Court has made the law very clear in the case of Union of India versus Ganpati Dealcom Pvt Limited 2022, in which the Supreme Court has held that because these are the penal provisions in the Benami Act, and the penal provisions cannot be made applicable with retrospective effect. The simple logic was that when the transactions were entered into, the assessee was not aware of the penal provisions, so the penal provisions cannot be made retrospectively applicable. This was the main foundation of that judgment. But the review petition was filed in the Supreme Court, and in the present case, on the basis of that review petition, the department was challenging the order passed by the tribunals in favor of the assessee that the Prohibition of Benami Property Transaction Act 1988 as amended by 2016 does not apply to the various assessees in which the department has filed the appeal before the Madras High Court. When the Madras High Court heard this batch of appeals, the court was of the view that the Madras High Court has already taken a view in a separate batch of cases where the Madras High Court has held that the appeals of the revenue should be not allowed, but with a rider that if the Supreme Court allows the appeal of the review appeal of the revenue, that in that case the revenue will get every right to further contest the matter. So the status was kept same of the order passed by the tribunal with a rider that if the revenue is able to win its case in the review appeal before the Supreme Court, then they will have every right to start their matter afresh in the High Court. Friends, this case is a very welcome judgment because the revenue gets very enthusiastic whenever they file the appeal and they try to argue that the appeals have been filed. So because the matter has been settled in favor of the assessee, simply filing the review petition does not change the position of the law. But if the decision of the Supreme Court goes anyway, so according to that decision, the further decisions will be taken, and the appeals of the revenue were not allowed, but with the rider that they will get the benefit to continue their appeals if the review petition comes in their favor. Friends, this is a very balanced judgment, and it will avoid a lot of litigation and a big relief to the assessee in case of all those cases where the appeal of the assessee has been allowed by the tribunals by stating that the Benami Act does not apply to the transactions prior to 2016. At the end of this video, once again, I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Benami Prohibition and others versus Anjani Constructions Pvt Limited, and this case is reported in 478 ITR at page number 670, and the date of the judgment is 23rd February 2024. Thank you, friends.